that we are going to hear this morning is Lecadia Lumbog versus Fernando Suansing. It's case number 29135, and each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Now, if you want to reserve time, let me know and I'll keep track. Also, I should note that the times are on the screen, so that's the exact same time clock that I have before me, so make sure you keep an eye on that as well. The arguments are recorded, so please keep your voice up and stay at the podium. If there are minors involved, please just use the initials, refrain from using any children's names. The court has read the briefs in this matter, and we are ready to proceed if you are. Attorney Dalianos.
Yes, may it please the court, judges, counsel. On behalf of the appellant, a brief statement of what occurred. The appellant may have come into a law office on a Thursday night and decided to file objections to magistrate's decisions. On a Friday morning, which apparently is 15 days after the magistrate's decision was rendered, is when the objections were filed, the following morning. Following that, the trial court issued a decision. The decision stated that the trial court believed that the objections were filed untimely. We then reviewed the information, and we then timely filed a response to the trial court. As we sit here now, we timely filed the appeal of a decision that the trial court entered. The issue involved here is whether or not, in a magistrate's decision, the time for filing of the decision counts, and then under the rule, which says that the clerk shall serve, whether or not the shall serve requires a 3-day also additional time period for mailing. In the case sub judice, the matter was mailed in the decision, which is attached to the appellant's brief via the clerk's office via mailing. That mailing is dated on June 1st. June 1st plus 3 days for mailing under appellate or under Civil Rule 6D, which allows for 3 days for anything to the service of notice. Under appellate, under local rule, it requires that the decision be mailed by the clerk. It says served. The words under Rule 6 says time for additional after service, which this was served. Appellee cites a lot of cases, and I went through each and every one of them. They are not from this district. Many of them from the 7th District, 10th District, 4th District, but none of those argued the day of the 1 day. Every one of those cases talked about the 3-day mailing and whether or not the magistrate's decision allows for 3 days. In those decisions, it said that it was not permitted. Appellee cites a Supreme Court of Ohio case that talks about Pulford. And Pulford seems to be what all these other cases seem to refer to, but that's out of the 3rd District. And when we look at Pulford, it talked about how the trial court even had the ability to review all questions of law. And that case had to do with a referee report. It didn't have anything to do with the magistrate's decision. So even Pulford and the Gonitz versus Ohio Adult Parole Authority, which is what's cited over and over in the briefs, talk about a referee report. A magistrate's decision, though, is under local rule out of Summit County. It states that objections shall be filed within a certain time. Under Civil Rule 6A, under time computations, it says, in computing any period of time prescribed or allowed by these rules, by local rules of any court, by order of the court, or by any applicable statute, the day the act of enter default for which a designated period of time begins to run shall not be included. If that day is not included, as Appellee points out in his brief, this objection was filed 15 days after the magistrate issues his decision, it was filed. So with the 1 day of not counting of the day of the decision, the 15 days and allow the trial court to then be able to render a decision based on our objections.
Two questions. One, what does the magistrate's decision say as to when the objections are due? And number two, do you want to reserve any time?
I'd like to reserve 5 minutes, and the magistrate's decision states in there that objections shall be filed within 14 days. That's what it says. But under Civil Rule 6A, it says that under any local rule of of any court, the day of shall not be included.
So give me the local rule again?
It's Civil Rule 6, which I attached to appellant's brief. 6A states specifically, shall not be included. It says about any local rule of any court, by order of a court, or allowed by these rules. So any civil rule, any local rule, or any statute, the day of wouldn't have counted.
So you're talking about the 15th day shouldn't count?
The day of when it was filed, the magistrate's decision was
It was
filed.
on the 31st.
So if you take that day shouldn't count, then 14 days later, then we're on time.
Right, we started counting on the 1st, right? So doesn't that count as one?
They include the day of the magistrate decision as one in counting the 14 days. That's why they say it was 1 day late. If you don't count that day, then it's not 1 day late.
It was filed on the 15th.
And the decision was rendered on the 31st. So if you take 1 day off plus 3-day mailing, we still have another 2 days. The mailing didn't occur until the 1st.
I'll be honest with you, I'm getting very confused because it seems like you're intermixing the mailing rule with the just not counting the first day that the order is filed.
Because under Civil Rule 6, time, it requires you to do that. It says that if anything's done via service of a notice, but under Rule 53, D33, it says that it shall be served by the clerk on all parties. It uses the exact word served. So this magistrate's decision shall be served on all parties under 53 D33.
Okay, can we start over? Because I thought you were responding to Judge Schaefer that even without the mail rule, the 3 days, even without 6D, that it still would have been timely because it would have been 14 days if you don't count the day that it was filed. Wasn't that your argument, or am I confused?
I'm wanting to add both of them. I'm wanting to add the time for computation of the day of judgment where the decision does not count, which is under 6A.
Why do you care if we would say that doesn't count, you're timely? If the day of filing, you're saying that makes it timely, if it doesn't matter, I mean.
Well, as the justice pointed out, that would have then been 15 days.
Oh,
It wouldn't have been 14.
I thought you were disagreeing with her.
I was agreeing that we needed both.
Okay, all right, then that's what I meant, that was where the disconnect lied with me. Okay, thank you.
And under 6D, it says at additional time after service by mail. Well, Civil Rule 53D33 requires that the magistrate's decision be served by the clerk on all parties or their counsel. So if it's supposed to be served under 53D3, then under 6D, it says at additional time after service by mail, which is what I'm holding in my hand, which is what we attached as an exhibit. So it's served by mail, the day of should not count, and the 3 days should then also be additional from the day it was mailed. It was mailed on June 1st.
It might have been mailed on June 1st, but the actual order itself says you have 14 days.
Correct.
So there's a conflict there between which one trumps, right? 14 days or the 3-day mail in addition to 14.
And it's our position when you follow the hierarchy of the rules that we've been taught.
Right.
Federal Constitution, federal law, Ohio Constitution, Ohio law, civil rule. Well, the civil rule says this and this. So when I add 3 and 1 from the day of mailing, we're way timely. When she came in on a Thursday and we filed on a Friday morning, it was timely under these rules. We wouldn't have done it. Why would we waste our time? The rule allows it because service was made under 53D3 by the clerk to all parties. Why would they require that inside their own rule? And then the civil rule, which trumps the local rule, says that in computing all the time, even under local rules in any order of the court, where service or notice or other documents shall be required to be served by mail or commencement of carrier. Well, this was served. The rule required it under 53D33. Thank you.
All right, you all have the, are you done with your argument?
Yes,
You'll have the full 5 minutes. All right, counsel, you'll have 15 minutes.
Yes, thank you, Your Honor. Good morning, Judge Carr, Judge Tedosco, Judge Schaefer. My name is Attorney Eric Skidmore from the law firm of Skidmore & Associates. I represent Fernando Suansing, who's the appellee in this case. He was the defendant in the divorce case below. And we definitively, respectfully request that this appeal be overruled and dismissed. Primarily, I want to make sure that we understand that any recitation by the appellant in reference to a referee's report is a magistrate's decision. That was the vocabulary that was used 25 years ago. So Civil Rule 53 was amended, changed referee report to magistrate's decision, same thing. So any cases referring to a referee's report also, by implication, would also apply to a magistrate's decision. We primarily object and request that the appeal be dismissed because the appellant has absolutely no case authority whatsoever to support its contention that Civil Rule 6 applies to the objection period to object to a magistrate's decision. Civil Rule 53 is the governing civil rule with regard to this. Civil Rule 53 D3B1 specifically says that an objecting party should file an objection within 14 days of filing the magistrate's decision. It doesn't say receipt. It doesn't say dispatch. When the filing of the magistrate's decision is filed, it's go time. That clock starts immediately. If you are a practitioner, you will note that immediately because there is no forgiving with regard to filing that 14-day objection. Local Rule 2704A is the Summit County Domestic Relations Court's local rule. It also echoes that filing date is the date commencing the 14-day period. Local Rule 2704A, again, domestic relations local rule, objection shall be filed within 14 days after the date the magistrate decision is filed. Now, the way that would apply in this case, both these rules would apply in this case. The filing date of the magistrate's decision was May 31st, 2018. As a practitioner, you would note that. By the way, this was emailed to counsel that day because of electronic filing.
Objection is not any of that information.
Electronic filing, we take a judicial notice of the document.
Thank you. Go ahead.
And so the magistrate's decision was filed on May 31st, 2018. That's when the clock starts. The 14th day after the magistrate's decision is June 14th, 2018. That is a drop-dead date. You either make that or you're timely, or you don't make that and you're untimely. And if you don't make that and you're untimely, there are significant consequences under Civil Rule 53 for not making that deadline. Now, appellant had argued that there is no case law locally with regard to the application of the 14-day rule to the motion, to the filing of the magistrate's decision. In fact, there's an abundance coming out of the Ohio 9th District Court, and we briefed it. Let me talk about two of them. And the judges on this panel served on those panels. So let's go through the first one. This was the JB case that came out of Medina. It was determined by the Ohio 9th District Court in 2015. We have briefed this in our appellate brief. Judge Hensel wrote the majority opinion. Justice Schaefer concurred. Justice Carr concurred on this case. This case is substantially similar to the case that we have at bar. And that is, it came out of Medina, it was a family law case, and the objection was 4 days late, and the commencing of that time period ran on the filing of the magistrate's decision. So the lower court in Medina threw out the objection because it was untimely, and this court reviewed that case and dismissed that appeal. And two of the panelists on the panel before me right now served on the panel in the JB case. Recently, in the 2017 case, is the BF case. This case is substantially similar to the case at bar, both procedurally and factually. This came out of Summit County, which was subject to the local domestic relations rule that I quoted, 2704A. This was a divorce case, just like the case that we have at bar. In this instance, the reason why we picked this case is that Justice Schaefer also served on that panel and concurred in dismissing that case as well. In that case, they used the date of filing of commencing that 14-day period. And the reason why that case is so important is because the objection was filed 1 day late, on the 15th day. And the lower court overruled that untimely objection and threw it out. This Ohio 9th District Court heard that case and dismissed the appeal. And we are asking that this panel also dismiss the appellant's appeal for the same reason. Now, appellee did indicate that in our brief, we did brief other cases outside of the Ohio 9th District Court that held the same way. Now, these cases were before the cases that I cited from the Ohio 9th District Court, but they used the calculation of the 14-day objection period from the date of filing the magistrate's decision. There's no discussion with regard to Civil Rule 6A or Civil Rule 6D. And in the cases that we cited, the King case, the M&J Auto case, the Theodore case, all these cases are family law cases. They're outside of Summit County. But we picked these cases because we specifically measured the date of filing the magistrate's decision and when was the untimely objection filed. And it was filed on the 15th day. So in all three of these cases, the King case, the M&J Auto case, and the Theodore case, the objection was filed on the 15th day. It was untimely, just like the case at bar. And those appeals were overruled and they were dismissed. Now, appellee attempts to interject Civil Rule 6D, the 3-day mailing rule. The reason why that rule does not apply is because it's contingent upon service of the document. Then you increase the prescribed time period of your deadline. Civil Rule 53D3, which addresses magistrate's decision, says that you count on the filing of the document, the filing of the magistrate's decision. That's when the clock starts running. And as a practitioner, when you get that, whether it's in civil court or domestic relations court, you note that immediately because you know you either got to file an extension of that deadline or you have to meet that deadline, but the consequences are severe if you do not meet that deadline. Now, I want to make sure that one of the reasons that one of the ways you can interpret Civil Rule 53D is by looking at the staff notes. I indicated that magistrates' decisions 20 years ago were referred to as referee's report. In a 1975 staff note for Civil Rule 53, it states, the time period for objection is keyed to the filing of the referee's report, which means keyed to the filing of the magistrate's decision in the year 2018, not the receipt by the objecting party. Now, we have plenty of case law that we cite that defeats the 3-day mailing rule. We had the Duganis case, we had the Clemens case that was decided in 2002, and each one of these cases is cited in our brief concludes that Civil Rule 6D is not applicable to extend the 14-day deadline from filing of a magistrate's decision. Now, as I said, if you have an untimely objection to a magistrate's decision, only bad things can happen thereafter. It's almost like procedurally the fruit of the poisonous tree. This procedure is poisoned. If you don't meet that deadline, everything that comes out after that is poisoned. Here's the way it works with regard to Civil Rule 53. The appellant filed the appeal to the wrong order. You got to file an appeal to a final appealable order. The final appealable order in this case was the May 31st, 2018 magistrate's decision, which was adopted by the trial court in a judgment entry. That starts the clock not only on the 14-day period for objection, but also on the 30-day to file a notice of appeal. That's your final appealable order. What happened here is that the objection was untimely. There's a subsequent ruling on July the 11th on an untimely objection, and they appealed that order, which is not a final appealable order, on August the 3rd, which is too late to file an appeal for the final appealable order of May 31st, 2018. So technically, the Court of Appeals can review only final appealable orders. Technically, I believe that this Ohio 9th District Court has the authority to dismiss this appeal for lack of subject matter jurisdiction because it's not pursuant to an appeal of final appealable order. Now,
let's say, just for argument's sake, that the trial court adopted the magistrate's decision in this case on June 30th.
if
the trial court adopted the magistrate's decision, and the court was sick or couldn't get to it and didn't adopt it until well beyond the 14 days.
yeah, so
Would the impact of that, would the objecting party still have the right to appeal that court's adoption of the magistrate's decision, even though it was late?
Well, because it's late, everything's out of kilter. Now, the cases that Justice Carr sat on and Justice Schaefer sat on treated that almost as a rogue order, because the untimely objection's untimely, you have a judgment entry, and the majority in that case by Justice Justice
Hensel.
Hensel, treated that as a rogue order and followed the Ohio Supreme Court case in Pitts. And in that case, they addressed a motion for reconsideration. Anybody knows that a motion for reconsideration is not the civil rules. Neither is your question either. So the question became to the Ohio 9th District Court panel, how do we treat that? And Justice Schaefer, Justice Carr, and Justice Hensel all held that the appeal should be dismissed because it's not a final appealable order.
Well, I don't mean to be picky, but actually I dissented.
Yeah, you concurred in the conclusion and you had a dissent.
Yes, because I didn't agree that Pitts could be applied.
Correct.
Reconsideration analogy could be applied to this.
Correct. So we had a concurrence of all three panel, but Justice Carr had a dissent, and her dissent dealt with the fact that she didn't want to bridge to find that Grove judgment entry. She didn't want to find that to be void and a nullity. She wanted to look at Civil Rule 53 and say, listen, the time periods and the way you treat those types of orders are in Civil Rule 53. I'm not going outside of Civil Rule 53 to address that issue. So Justice Schaefer, Justice Carr, Justice Hensel all concurred in the conclusion, but Justice Carr dissented on the reasoning to get there.
Thank you.
And so the last thing that happens when you have a untimely motion, you have really two more things. And that is, when you file a timely objection to a magistrate's decision, it provides for an automatic stay and pulls the execution. That's important because in Justice Teodosio's analogy, if that objection had been timely, it would have forestalled the notice of appeal until there was a timely judgment entry ruling on that timely objection. That's when the notice of appeal would have started. Now, because it wasn't done and it was untimely, the notice of appeal was not told. Therefore, 30 days after the final appealable order of May 31st, 2018 is when he had to file a notice of appeal. They didn't do it. So that's a waiver. It's another reason why that this appeal should be overruled and dismissed. So in conclusion, on behalf of the appellee, we respectfully request that because of the application of the case law in the Ohio 9th District Court, the sisters courts of appeal in Civil Rule 53D, that this appeal should be overruled and dismissed.
Any questions, Judge Schaefer? Okay, thank you for your argument. We'll hear rebuttal. You have 5 minutes, Attorney Pelianis.
Judge Schaefer, I just want to present as to the reason why I was confused as to the time period, if it included a day or not. In the court's decision by Judge Cook, it said in here that the magistrate's decision was filed on May 31st, 2018. Plaintiff had until June 14, 2018 to file any objections. Based upon this procedure issue, this court cannot rule on the merits of this objection. Therefore, plaintiff's objection filed on June 15 is hereby overruled. So it seems like the court there gave me the application of Civil Rule 6 on the top part of A and didn't include the day of the filing, because that's how you then get the 14 days, is in the 31st. If the 31st is not included, then 14 days later would be June 14th, which is how the court got there. So the court gives appellant the application of Civil Rule 6A on time computation. It doesn't include the day of, but doesn't give appellant the benefit of Rule 6D, which says that 3 days shall be added therein as prescribed by the rules, if there's service to be had. Appellee presents that under Rule 53 is how they get their authority, but under Rule 53D3 III, it says specifically that the clerk shall serve upon the parties or the attorney. So when you add those 3 days as followed by the rule, it would then get us in time. Regarding the Pulford v. Pulford decision, that decision, in fact, that was cited by appellee, said that you have the right to still review questions of law, even if the objections may have been untimely to the magistrate, to the trial court. So in Pulford v. Pulford, as long as it's brought before you, it says that you can review questions of law that were considered by the court or the referee. So the questions of law here is whether or not those days should be included because the court considered it. Under Rule 53, it says that the trial court even has the authority to issue any other decisions it wants, whether I file an objection or not. So the court, when it issued that decision, it had the authority to do it under Rule 53. The question is not whether or not we had the jurisdiction to file the appeal. The question is not under law. The question is under law whether or not you would add the 3 days and give the benefit of appellant under Rule 6D, as the trial court gave it under 6A by not including that day in its decision. It says the decision was filed on the 31st, you had until the 14th. So it did not include the day. It gave us the benefit, so why wouldn't it do it on the other part of it? The last part of it that I would present is anything I learned in law school, everybody had a right to due process and notice. I don't think that this magistrate's decision rule had in there that if a person never gets served with a copy of this decision, that somehow they need to file it within 14 days. Everybody knows that the time computations allow for a person to get notice of what's going on, to then give them the proper time to then object or do what they need. On the record, appellant presented an envelope that under Rule 53 was sent to them via mail. 3 days are added from that, from June 1st. An envelope was attached as an exhibit. It's for you to review. Civil Rule 6A was given the appellant. 6D should also be given the benefit of the appellant. We therefore believe that the trial court was in error in believing that the objections were untimely filed, and this matter should be referred back to the trial court because it was timely filed, and the trial court then under Rule 53 re-reviewed the matter. Thank you.
Thank you both for your arguments today. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will certainly mail each of you a copy of the decision on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. Thank you both again for the arguments.